Hello everyone, welcome to BYD Classes. Welcome to the next session of Means 365 Current Affairs or 2023 examination. So let's begin the discussion. So here that we will discuss the free legal aid in India. What is free legal aid? Here given it is a definition of free legal aid. It is the provision of free legal services in civil and criminal matters for those poor and marginalized people who cannot afford the services of a lawyer for the conduct of a case or a legal proceeding. So here free legal aid available for those which are very poor, like below poverty line and other weaker sections of the society. And free legal aid given in Article 39 capital A provides for free legal aid to the poor and weaker sections of the society and ensures justice for all. And why free legal aid? Because it is promoting access to justice for all and it addresses long pendency of cases. 77% inmates are under trials in 2021. So it is a very long cases pending in the court. And equal protection under the law, promotion of social justice and protection human rights, and it is preventing wrongful convictions. So free legal aid helps for the poor and other marginalized sections of the society. And steps taken so far. Free legal services are provided under Legal Services Authorities Act 1987 and are operationalized by National Legal Services Authority. And pro bono legal services. It is initiative is a web-based platform, means the online portal through which interested lawyers can register themselves to volunteer pro bono services for the underprivileged litigants who are unable to afford it. And tele-law initiative means it would connect lawyers with clients through video conferencing facilities at CSCs operated by paralegal volunteers. And CSCs including stands for Civil Service Compensation Schemes and it is operated by paralegal volunteers. And Lok Adalat, which serve as a platform for amicable resolution of pending cases in courts or those in the pre-litigation stage. So remember this. And what are the challenges in accessing legal aid? Lack of awareness, because lack of resources with the poor and marginalized sections, it leads to exploitation and deprivation of rights of the poor. And geographical barriers, it challenges in providing legal aid services to remote and rural areas, and inadequate funding hampers their effectiveness and limits the resources available, for example, less number of impaneled lawyers. And overburdened judiciary, high volume of cases leading to delays in the provision of legal aid, and poor funding. Per capita spending on legal aid in India is 0.75 rupees as per study of Commonwealth Human Rights Initiative. And poor quality of service, as per the report of NLUD, about 75% of beneficiaries opted for free legal aid as last option, and no legal aid at the police station, despite Article 22 guarantees the right to a lawyer for an arrestee. So here, what is the way forward? Public awareness. to inform the educate and public of its right to free legal aid and inclusion of all designated senior lawyers in the legal aid schemes and requesting them to undertake the at certain cases free of charge every year and better payment to the lawyers who provide legal aid and training paralegal volunteers through training programs for students, social workers, and jail inmates, etc., and regular feedback to gauge the quality of legal representation. So remember this. And fast track special courts. What is this? Recently, the law minister presses for accelerating setting up of fast track courts and fast track special courts. What is difference between fast track court and fast track special court? These are dedicated courts expected to ensure swift dispensation of justice. And initially 11th and subsequently 14th Finance Commission had recommended setting up of fast track courts and fast track special courts to deal with cases of heinous crimes, civil cases related to women, children, senior citizens, HIV or AIDS related cases, etc. Related cases pending for more than 5 years and fast track. These are under fast track courts and under fast track special courts. These are set up under a centrally sponsored scheme for hearing rape and protection of children from sexual offences act cases, and their setting up and functioning falls within the domain of state government in consultation with their respective high courts. Fast track special courts are linked to national judicial data grid. And what is the data about the fast track court and fast track special court? In fast track courts, it is of the sanction under 1800 fast track courts and 840 were functional as of January 2023 and pendency increasing by 40% since 2020 because the about 1800 fast track court, out of this the 843 are functional and remaining are pendency increasing by 40%, and of the 1023 sanctioned fast track special courts, out of this the 764 fast track special courts including 411 executive POCSO courts are functional in 28 states or union territories as of January 2023, and here 1.98 lakh cases are pending in these fast track special courts. So remember this. And what are the benefits of fast track courts and fast track special courts? These fast track court and fast track special courts provide speedy access to the justice and act as deterrent for sexual offenders and declosing judicial system of the burden of case pendency. And what are the issues with fast track special court? These are inadequate staff. These have inadequate staff and IT infrastructure, delay in getting reports from understaffed forensic science laboratories, and inadequate number of judges. No legislative foundation which sets up out the purpose of these courts and any special time bound procedures to be followed. So remember this. And what is the way forward to set up fast track court and fast track special court robustly? Apart from increasing number of judges, equal attention must be paid to both metropolitan and far-flung non-metropolitan areas, and once established special courts should be subject to periodic monitoring and evaluation to assess their performance and effectiveness, and judicial officers and prosecutors should be selected based on their attitude, knowledge and skills and given special sensitization training, and mechanisms for collaboration with other court agencies and non-government organizations should be developed, and comprehensive legislation should provide for victim support services including interpreters, social workers, and other services to protect victims, enable them to testify in safety, and reduce the trauma they might experience. And online justice delivery. Why it is in news? Because recently, for the first time, the Supreme Court has live streamed its proceeding, that is live live proceeding in the open manners and in the IT IT rules. Okay, in 2021, Supreme Court's E Committee came out with model rules for live streaming and recording of court proceedings in India. And earlier 2018, Swapnil Tripathi versus State Supreme Court declared live telecast of court proceedings part of the right to access justice under Article 21 of the Constitution. And currently, 6 high courts, namely Gujarat, Odisha, Karnataka, Patna, and Madhya Pradesh, have live streamed court proceedings through their channel on YouTube. And live streaming of Supreme Court proceedings in part of the third phase of the e-court project, an initiative to implement use of information and technology in judiciary. And what are the challenges with online justice delivery? Lack of investment in court and IT infrastructure, as e-courts require new age technology like high-speed data, cloud computing, availability of sufficient bandwidth, and lack of technical know-how among court officials and staff, and absence of dedicated in-house technical support, and low awareness among litigants and advocates, and digital divide in access to justice due to insufficient infrastructure, non-availability of electricity and internet connectivity, and low digital literacy in rural areas, and interdepartmental challenges due to lack of coordination, communication, and interoperability of software between various departments, and cybersecurity threats. Judicial data comprise of sensitive case information and litigant data. Their electronic storing and transmission fuels security and privacy concern, and procedural problems like authenticity of evidence received through video and or audio transmissions, identity of witness, confidentiality of hearings, etc. And what are the significance of online justice delivery system? Improving transparency and accountability in judicial system. An online resolution of contractual disputes will boost confidence of domestic and foreign businesses as they explore investments in India, and provide additional aid to clear backlog cases and reduce time and cost involved, and enhanced efficiency of courts. And reduction of paperwork will relieve judges and other court staff and allow them to focus on judicial functions. And real-time online data would facilitate better identification and classification of cases and enable high courts to supervise and control subordinate courts, and availability of judicial data relating to cases from courts across the country. So remember here the significance of online judicial system, online justice delivery system, and initiatives launched under the e-court project, such as newly launched project include virtual justice clock. It exhibits vital statistics at court level, giving the details of the cases instituted, cases disposed, and pendency. And Just IAS mobile app 2.2 tool for judicial officers for effective court and case management by monitoring pendency and disposal of cases, and digital court to make court records available to judge in digitized form to enable transition to paperless court, and S3 WAS scheme to generate, configure, deploy, and manage websites for publishing specified information and services related to district judiciary, and other initiatives such as interoperable criminal justice system to enable seamless transfer of data and information among stakeholders like courts, police, jails, and fast and secure transmission of electronic records, that is faster. It was initiative of the Supreme Court. It is a software to transfer court orders securely through electronic mode. SUAS, that is Supreme Court Vidik Anuvad software to translate English judgments into regional languages. And e-courts mission mode project is a national e-governance project for information and communication technology enablement of district and subordinate courts. It was conceptualized based on reports submitted by e-committee, that is the Supreme Court of India. And way forward, procedural laws or rules may need to be amended to incorporate the suggestions of having audio video recording of court proceedings, and design and impart regular training courses for judges, court staff, and paralegals for using online systems and maintenance of e-data such as records of e-file, minute entries, summons and warrants, and creating a user-friendly e-court mechanism and awareness generation which provides information in multiple Indian languages, and clear rules on data privacy. So here remember the online justice delivery, which is providing Supreme Court as well as High Court. And next is the alternative dispute resolution, that is ADR. ADR is what? ADR is a process in which disputes are addressed and settled outside of the courtroom. It offers to resolve all type of matters including civil, commercial, industrial, etc., and uses neutral third party to communicate and resolve dispute. Criminal cases involve the final settlement to be pronounced in court. In various jurisprudences, there are 5 types of ADR. These 5 types, such as arbitration, dispute is submitted to an arbitral tribunal which makes decision that is mostly binding on parties, and conciliation, it is a non-binding procedure in which an impartial third party, the conciliator, assists the parties to a dispute in reaching a mutually satisfactory agreed settlement. And mediation, under this, an impartial person called mediator helps the parties to reach a mutual acceptance resolution of the dispute. And negotiation, a non-binding procedure in which discussions between parties are initially initiated without intervention of any third party with the object of arriving at a negotiated settlement. A lok adalat, that is, it is also known as the people's court, and it comprises an informal setting which facilitates negotiations in presence of a judicial officer, wherein cases are dispensed without undue emphasis on legal techniques. Its order is final and not appealable in a court of law. So remember this. 5 types of alternative dispute resolution. A need of ADR to deal with the situation of pendency of cases in courts, thus reducing the burden on the court. And it is to provide social, economic and political justice and maintain integrity in the society enshrined in the preamble of the Constitution, and to achieve equal justice and free legal aid given under Article 39A in the Directive Principles of State Policy. And advantages of the alternate dispute resolution: less time consuming compared to courts, and cost-effective method, free from technicalities of the courts, as informal ways are applied in resolving dispute, and people are free to express themselves and can reveal true facts without disclosing it to any court, and there are always chances of restoring relationship back as parties discuss their issues together on the same platform, and it maintains good relationship between parties and preserves the best interest of the parties. And what are the limitations of ADR? An arbitration award is binding, that is, decision is final, thus lacks the ability to appeal the decision, and little or no check on power imbalances between parties and may not protect parties' legal rights. And cross-cultural language barrier during ADR process widens the gap to resolve dispute, and lack of compulsion, as no party can be compelled to continue negotiating. Any party can terminate negotiations, notwithstanding the time, effort, and money that may have been invested by other parties or other party. Lack of awareness among the people. So these are the limitations of about ADR. And what is the way forward? Awareness can be brought by holding seminars, webinars, and workshops. And judicial officers must be trained to identify the cases which can be solved outside the courts, and mediation centers can be set up in districts and tehsil areas to help citizens to resolve their disputes quickly and without going for litigation process. And ADR mechanisms should be made more viable to address huge inflow of cases in judiciary, and ADR decisions should be made binding upon the parties, which is not the case at present. Okay, so this is the about ADR, so you can remember very easily. And next is the tribunal. Why it is in news? Recently, Supreme Court clarified that the provisions of the Constitution do not prohibit the central government from abolishing a state administrative tribunal. The Supreme Court held that the abolition of Odisha Administrative Tribunal was constitutionally valid, and Supreme Court was hearing an appeal filed by the Odisha Administrative Tribunal Bar Association against a High Court order that upheld the notification issued by the central government on August 2, 2019, which abolished Odisha Administrative Tribunal. So, the Supreme Court had noted in its order that there was sufficient material to support the views of the state government. Sorry, not Supreme Court but High Court here stated in order that there was sufficient material to support the view of the state government that Odisha Administrative Tribunal has not served the purpose of delivery of speedy justice to litigants. And Supreme Court observed that Article 323 capital A does not preclude the Union government from abolishing state administrative tribunals because it is an enabling provision which confers the Union government with power to establish an administrative tribunal at its discretion. And data about the tribunal. Pending cases as per 272 Law Commission report. Central Administrative Tribunal, the cases pending, that is 44,333, and in Custom, Excise and Service Tax Appellate Tribunal there were more than 90,000 cases, and in Income Tax Appellate Tribunal there were more than 90,000 cases were pending, and Armed Forces Tribunal there were more than 10,000 cases are pending. So you can remember this. And tribunal system in India, this is the static part, but we can see here the tribunal system. The tribunals are judicial or quasi-judicial institutions. These are not constitutional or the but it is a statutory or quasi-judicial institutions established by an act of parliament or state legislature under Article 323A for parliament or union administrative tribunal and 323B under the state administrative tribunals through 42nd Amendment Act 1976 on recommendation of Swaran Singh Committee. And under Article 323A deals with administrative tribunals and 323B deals with tribunals for other matters. So remember this. And they provide a platform for faster adjudication of disputes as compared to traditional courts, as well as expertise on certain subject matters, and tribunals are not obliged to follow all rules and regulations imposed by Civil Procedure Code and Indian Evidence Act, but they have to follow the principles of natural justice. And tribunals have been vested with powers of civil court in respect of some matters, including the review of their own decisions. That is, the decisions are legally binding on parties subject to appeals and need of the tribunal system. Administrative tribunals are handled by experts and thus are able enough to solve such issues and reduce the burden of constitutional courts and judicial delays. And speedy justice mechanism and tribunals are cheaper and more suited than a court in effective hearing of technical matters disputes. And what are the issues of administrative tribunals with the tribunal system? Lack of independence. In 2010, Supreme Court noted that tribunals in India have not achieved complete independence because system of appointment through selection committees severely affects an independence of tribunals and non-uniformity across tribunals with respect to matter of qualifications, appointments, service conditions, tenure of members lead to malfunctioning in managing and administration of tribunals and staff shortage. For instance, Central Administrative Tribunal has 27 out of 64 posts lying vacant and leaving some benches without requisite strength to assemble and hear cases, and inadequate judicial infrastructure, that is, courtrooms, basic amenities, etc., for judges, advocates, and litigants in subordinate judiciary and tribunals is serious issue. And high court or a high rate of pendency due to avoidable adjournment and absenteeism, high dependency on the parent ministry for finances, and breakdown of doctrine of separation of powers. Executive interference in functioning of tribunals is often seen in matters of appointment and removal of tribunal members, which is against the principle of separation of powers. And speakers as tribunal. Speaker office has been under controversies for its decision on disqualification of MLAs, and Supreme Court asked Parliament to rethink whether disqualification petitions ought to be entrusted to a Speaker as a quasi-judicial authority, as a Speaker continues to belong to political party either de jure or de facto, and Parliament may seriously consider amending the Constitution to substitute a Speaker of Lok Sabha and Legislative Assemblies as arbiter of disputes concerning disqualification which arise under 10th schedule with a permanent tribunal. And what is the way forward? Independent autonomous body, setting up of National Tribunal Commission under Ministry of Law and Justice for monitoring the working of tribunals and ensuring the uniformity in appointment system. An idea of National Tribunal Commission was first mooted by Supreme Court in L. Chandra Kumar versus Union of India 1997. And selection of members, it is to ensure impartiality, which is given in 272. Law Commission of India advised minimizing government agency involvement in member selection and considering its frequent litigation participation and filling vacancies in tribunal as early as possible by initiating the procedure well in time, preferably within 6 months prior to the occurrence of vacancy. And tribunal must have benefits in different parts of the country to ensure access to justice by people across geographical areas. Ideally, these benches should be located where high courts are situated, and tribunals must have benches in different parts of the country to ensure access to justice by people across geographical areas. And ideally, these benches should be located where high courts are in situated. And qualified manpower. Members in tribunal should be a person of ability, integrity, and having a special knowledge of and professional experience of not less than 15 years in the relevant domain. An stringent provision for time-bound redressal must be incorporated in all statutes dealing with tribunals. And next is the Central Information Commission. This was in news, and that is recently Parliament Committee has urged the Staff Selection Commission to investigate the reasons hindering direct recruitment in Central Information Commission, which employees may outsource employment or employees. So it is a static portion, so you can read from your notes as well as from standard books with issues as well as challenges for Central Information Commission, and it will be the very need to remember the way forward to reform in the central or selection in the Central Information Commission. Okay, and next, the right to information. Right to information. What is right to information? RTI Act is a fundamental. Right to Information Act is a fundamental right and is a aspect of Article 19 Clause 1 Subclause A of the Indian Constitution. Right to Information Act 2005 mandates timely response to citizen requests for government information, and provisions of RTI Act 2005. Section 2 Clause S. Public authorities means all authorities and bodies under Constitution or any other law, and inter alia includes all authorities under central, state governments and local bodies. And Section 4(1) Clause B. Maintain and proactively disclose information. And Section 6 under this it prescribes simple procedure for securing information, and under Section 7 it fixes time limit for providing information by public information officers, and under Section 8 only minimum information exempted from disclosure, and under Section 19 the two-tier mechanism for appeal. So remember this. What are the benefits of right to information? To empower citizens by equipping them with power to seek information from public authorities, and promote transparency and accountability in working of the government, and reduce corruption and make democracy work for the people in a real sense, and ensures strengthening of government public relation due to increase in communication, and helps the right to information helps to improve government records or database management and increasing awareness of citizens, and it increasing awareness of citizens regarding governmental functions and strengthen parliamentary democracy. So remember this. And what are the challenges related to right to information? Poor record keeping practices, within the bureaucracy results in missing files and lack of infrastructure and staff for running information commissions, and lack of awareness among masses, lack of proactive declaration of information by the government, and increasing frivolous right to information applications, and huge pendency and delays in disposal of right to information application. And what is the way forward related to the strengthening right to information? To enhance number of information commissioner in chief information commissioner to quickly dispose pending cases, and campaigning through the publication of Right to Information Act 2005 in regional language, adding a chapter on Right to Information Act 2005 in school or colleges curriculum to create awareness among citizens, and protection of whistleblowers disclosing information in the public interest, and declaration of information by government proactively, and training of person of Indian origin, person or public information officers experts for handling right to information applications. So remember these the initiative or role of the government or the public in right to information. And other important news such as the New Delhi International Arbitration Center 2022 Act. So Parliament passed the New Delhi International Arbitration Center Amendment Bill 2022, and it amends the New Delhi International Arbitration Center 2019 and renames the New Delhi International Arbitration Center as India International Arbitration. So remember this. And features of this act is manner of conduct of arbitration and other forms of alternative dispute resolution will be specified by the central government, and it allows government to provide for removing any difficulties in implementation up to 5 years from date of commencement of this act. And what is international arbitration? It means settling international commercial and business disputes through arbitrators, where parties opt for a private dispute resolution procedure instead of going to court. And availing international arbitration can be optimal, but it could also be made compulsory by inserting a mandatory arbitration clause. And arbitration awards are more widely and readily enforceable due to Convention on the Reorganization and Enforcement of Foreign Arbitral Awards 1958 New York Convention, and through bilateral investment. And it under Article 142 was in news, and in this the Supreme Court held that it could directly grant divorce in cases where marriage has irretrievably broken down, dispensing with period prescribed under Hindu Marriage Act. So you can remember under Article 142. So given here the complete justice by the Supreme Court and power to promulgate by the Supreme Court. Okay, and judgment and scope of the justice system given by the Supreme Court of India. So here the next part is the criticism of Article 142, like sweeping nature of these powers are arbitrary and ambiguous, and absence of a standard definition for the term complete justice, and violation of the separation of powers doctrine. Okay, so you can remember this Article 142 which was in news. So here I will end the lecture, and next lecture would be the election in India, about election commission and elections. Okay, so here thank you for watching. Have a good day.